Okay, I've got your screen now. So now we'll turn the presentation over to Jim Wright and Jordan Cullimore from the Utah Office of Property Rights Ombudsman.
Great. Hey, thanks, Jason. We really appreciate that. So I'm Jim Wright, an attorney with the Office of the Property Rights Ombudsman. I'm here with my friend and colleague, Jordan Cullimore, also an attorney with the Ombudsman's Office, and we are thrilled to be here today to, as Jason explained, give a legislative update on certain land use and eminent domain laws that came up in this last session. So as we get going here, we'd like to start off with a brief session introduction to go over some of the things that we saw from this session relating to those areas that we're going to be covering today. So Jordan, in terms of past bills, what kind of things did we see here from this last session?
Yeah, so with this session, we did see a lot of kind of trends or themes, right? One of the first ones that we've discussed is the theme of affordable housing and housing affordability. As we know, a lot of it's been in the press a lot, both related to prices are going up. Will wages be able to maintain pace with the price of housing, as well as availability, right? And I think for the first time in remembered history anyway, there are more people who want to buy a home than there are homes to buy, right? And so that's having an effect on housing affordability. And then kind of as a subset of that issue, we're looking at homelessness, right? What's causing homelessness? What are the effects of homelessness? How can we help those who are experiencing homelessness to get out of it? So we're going to talk about and see a few bills related to housing affordability, as well as affordable housing and homelessness, I think.
Great. Yeah, definitely one of the big themes of the session, and like Jordan said, we'll get to that in just a minute. I think there were also some other things we saw. The Ombudsman's Office actually had a couple of bills that added to our jurisdiction on some things here we'll get to in a second. So that was something else I think that, there have been certain bills in the past, but they've never passed. However, this session they did pass, and so we'll get into some more detail on that here in just a moment. In terms of just numbers,
right?
I feel like this session and for this presentation, we're going to have a much higher number of bills that we're going to be going over.
Yeah, and that's one thing you and I discussed, right? Is it seems like you and Brent did the update last year. The year prior to that, you and I did it, and it seemed like we were only focusing on a few kind of really key bills. But this year, as we came up with our list, there's just a lot of stuff going on, right?
The list just kept going and going.
Yeah, and a number of those came from the Land Use Task Force, which was good to see that they were, producing some consensus legislation and and kind of helping and one thing I thought about that was interesting with the land use aspect of things is there weren't necessarily a lot of new rules or laws put in place. But there was those changes to LUDMA, the Land Use Development and Management Act, last year. They made several tweaks. This year they seem to refine that, right? There wasn't necessarily new rules, but there were a lot of situations where, hey, we have these issues or things that came up, and so there's clarifications and tweaks in language, and we'll talk about what those are as well.
Sure, right. Yep, and in terms of FEL bills, and this happens, it seems like every year where there's certain land use bills or bills that may impact land use that keep coming back. And so we'll briefly go over a couple of those bills that we seen again, and a couple of the key FEL bills as well. And then, of course, what's next? There are a few things to keep our eye out for. One of these, Jordan, is there's going to be a large number of legislators turning over. The leadership in both the House and the Senate will be changing, and there's going to be an unusual high number of legislators not coming back. So that's one thing. So we'll
not
see
just legislators, but legislators that have been kind of high profile, right?
Yeah.
Had a lot of sway and things. Yeah.
So we'll see how that works. Of course, as you mentioned, the Land Use Task Force, that is definitely going to continue to be an important vehicle for land use bills. And it'll be interesting to see how these new legislators coming on board end up fitting in with that process. And you know, again, assuming that things are going to keep going well with that, but that is, you know, certainly something to keep our eye on.
Yeah, and we'll talk more about the land use task force as we are doing our presentation, but that's one kind of group that has gone through some changes and some as far as who's running it and those types of things, but it's come out strong, and everyone involved has made a commitment to really move forward and continue to try to make things easier and more understandable for all the parties involved, which I think is a great thing.
And just to make sure we're not assuming anything, Land Use Task Force, of course, is a group of local governments, as well interests and their representatives, as well as private property owners, the Property Rights Coalition, and other private property rights interests that meet together to try to form and hammer out consensus bills on land use and property rights. This has worked really well in Utah over the last few years. So, and maybe one other thing that's on everybody's mind, and this is the image here you see on this slide, is what will the Utah legislature do for an encore to their music video that they produced this year, showing how a bill becomes law. So I know that video went viral.
If you haven't seen it, check it out.
You should. Okay. Anything else before we jump into the...
No, I think that's kind of a good roadmap, and yeah, we can kind of jump in and talk through everything.
Okay. So we'll go ahead and start off here with the Ombudsman's Office bills. There are a couple of these that impact our office. As I mentioned, we have had some additional jurisdiction and responsibility given to us. The first bill, HB 250, impacts our office by mandating that we now provide training on land use laws and regulations, as well as land use dispute resolution. Of course, you know, we have been providing training on these topics in the past, but they have not been necessarily as much of a focus as they will be going forward. And specifically, we will be on the land use laws and regulations coming up with a model ordinance that people will be able to access. Of course, that's going to be a very large undertaking, and it will undoubtedly happen incrementally, but just want to let you know that that will be happening, and you can keep your eye open for that and use that as a resource, as well as if there's anything we can do to provide training on these topics, you know, please let us know, as that is now a specific focus of our office. You know, again, even though we did it before, it's now even more front and center on what we do.
The idea there is that we'll be bringing kind of, you know, really common provisions and trying to insert some best practices and good language that we see in dealing with different communities, and also in the literature and those types of things. So that's a resource that people will be able to turn to, say, hey,
for the model ordinance,
we need to update our conditional use permit ordinance. Where's a good baseline standard to start with, and hopefully that's our intent, right? Is to produce kind of a bank of some good starting points.
Right. So as a takeaway on this one, keep that in mind and keep your eyes open for that. In addition, this bill provided some funding for our office to be able to provide this training. And not only for our office, but our office has the ability now to provide grants to organizations that may want to provide this training as well on the land use laws and regulations. And so if you or an organization that you're aware of may be interested, there will be the chance to apply for these grants. And our office, the Executive Director of the Department of Commerce, and then the Land Use and Eminent Domain Advisory Board, the board that governs our office, will be approving those grants. So just keep in mind that this bill did provide that money as well. On a separate note here on this bill, there was a provision that came out of a Utah, well, that largely came in response to Utah Supreme Court case, Alpine Homes. And in that case, the Utah Supreme Court indicated that developers who had paid impact fees did not have standing to challenge how those fees were spent. They only had standing to challenge whether or not they were constitutional at the time that were charged. And so what this bill does in addition is it indicates that if you pay an impact fee, you have standing now to challenge how it is spent. And if it was not spent, you know, in the 6 years spent or encumbered in the 6-year period, you have standing now to challenge that. And so as a takeaway on this, keep in mind you're going to want to make sure that you are appropriately spending or encumbering and otherwise using your impact fees, because there is another group now that has standing to challenge any government that does charge impact fees. Okay, on the canal amendments here, SB 96, this added to our jurisdiction in terms of mediations. And so what happened is there were a whole bunch of situations around Utah where developers were looking to develop their property, and the property had a ditch or canal or some other water conveyance facility on it, and needed to get rerouted in order for the development to work. And so there was conflict on occasion between the developer and this water conveyance owner over what was appropriate for the water conveyance owner to require of the developer and the property owner in order to get approval to develop the property. And so this bill attempts to set up a framework to resolve these kinds of disputes by explaining when a private property owner can and under what circumstances they can move the water conveyance facility. And it also gives our office jurisdiction to mediate these kinds of disputes. And we just mediated the very first one of these situations yesterday. And it got off to a good start. The parties seem to be pleased with how the process went, and we hope that we'll be able to provide good service to folks who are in that situation. And so, as a takeaway from this one, keep in mind that if this situation arises in the community, that there's now another resource, for people to try to get that solved. So.
Yeah, and our understanding is that this is becoming an increasing occurrence, right? Because as development continues to grow from urban and suburban areas into more rural areas, you have these canal companies and water conveyances that are on property that property owners are trying to develop, and this is something that's come up in our office, and so hopefully this can be a good tool that local government officials can direct property owners to, and even canal company owners to say, hey, if you need some help trying to reach a solution, the Ombudsman's office can now help to do that. So, okay, so as you can see, we kind of have some general headlines and themes. The next one that we mentioned briefly and want to talk about a little bit as far as what the bills involved is affordable housing and housing affordability. And the general sense that I got on this issue, where it is in the news a lot, is that legislature kind of passed some bills to really show how interested they are in the issue, how much the issue is forefront in their minds, and that it's something that they are concerned about moving forward as Utah grows, right? We're supposed to double population, I think, by 2040 or 2050. And it's important that people have availability for housing, and that there's also affordable housing stock in communities that people have access to. So the first bill we want to talk about in that regard is HB 259, Moderate Income Housing Amendments. And this relates to local government's moderate income housing plan, right? And this is something that has been in state law for several years. I believe the sponsor of the bill mentioned that where it's not mandatory, only, I think the citation he gave, don't quote me on this, but it was something around 60 of 150 entities that should be producing a moderate income housing plan are producing a moderate income housing plan. And so kind of the purpose of this bill is to bring that more to local government's attention, and in doing so, it still exempts towns, so towns don't necessarily have to produce a moderate income housing plan, but most cities, metro townships, and counties now, as a mandatory part of their general plan, have to include a moderate income housing element. And the bill talks about specifically what that element has to include, what you need to be looking at. But the idea behind it is in that doing this plan, you're going to want to understand, what type of stock you have in your communities of affordable housing, and what type of provisions you have in place to encourage housing affordability, and then to actively plan for that. So not only does it require and make mandatory for several and most communities that moderate income housing plan is in your general plans, but it also requires you to regularly, on a 2-year basis, essentially review your moderate income housing plan and post it, post that review, the report of what you found on your local websites. And you do have resources to help you to gather this information and these metrics and data. There's the Housing and Community Development Division of Workforce Services, and my understanding is also if you're a city or town, you can reach out to the Utah League of Cities and Towns, and they can help you find some resources that will be helpful in that regard. So again, it was kind of the legislature's way of sending a message, hey, this is really important to us. It's not something that's been on the forefront of people's mind. Let's make it more visible in our planning, right? The next one involving this subject is the HB 430 Affordable Housing Amendments. Back in 2016, the governor commissioned a task force, a housing affordability task force, which produced some legislation in 2017. And the purpose of this bill is to essentially make permanent a commission on housing affordability that's comprised of public and private stakeholders. I think there's going to be about 20 individuals on the commission altogether. Their stated purpose will be to seek to increase awareness through empirical study and investigation. And you can imagine that it will probably produce some additional legislation, and at the same time, it will kind of increase awareness of what can be done to improve housing affordability and to encourage affordable housing in local communities. The last one to talk about is HB 462, Homeless Service Amendments. This is another thing that's been covered a lot in the news, right? Homelessness. You've probably heard a lot about the concerns in the Rio Grande area, where there's a high concentration of individuals who are experiencing homelessness at this time. And the idea is to move to a scattered site model. And so they've identified smaller locations to kind of spread the impact of homelessness throughout the state. Salt Lake, South Salt Lake, Midvale, Ogden, St. George, I think are a few communities that currently are or will be hosting some of these facilities. And those facilities need to be funded, right? They need to be paid for. The final version of the bill was actually not that exciting, right? It basically took, I believe it was $6.6 million to fund a few of these new facilities from the general fund at the state. The interesting part is that the earlier versions sought to look to local communities and kind of take a stock of the amount of affordable housing and low-income housing in those communities. And if it fell below a certain level, then sales tax was going to be siphoned off from those communities to help pay for funding these, scattered, smaller homeless resource facilities, essentially. And so the takeaway from this one is that, as the state looks and moves forward with funding these facilities, they've sent the message definitely that they view this as a statewide issue, right? That the whole state needs to contribute to, and so it's probably in everyone's best interest to try to really think about and consider, okay, how can we provide affordable housing for low-income individuals to try to help prevent and alleviate the effects of homelessness.
Okay, so there are a couple of eminent domain and acquisitions type bills that came out of this legislative session. So this first bill, HB 62, sort of bucks the trend a little bit of where the legislature sees what the Utah Supreme Court does and decides to change it. This case is where the Utah legislature saw what the Utah Supreme Court did and said, yes, we like that. We want to codify what you did and agree with it. And so what this bill does is it codifies the portions of the famous Admiral Beveridge case. It's a very famous case in Utah for eminent domain. And basically what that case did is said that when you have a partial acquisition in eminent domain, you need to value the remainder parcel based on what a willing buyer and a willing seller would pay for the property, or in other words, its fair market value. Okay, so it's pretty, a pretty straightforward application there on the remainder parcel valuation, and this bill basically simply codifies that. So that's HB 62. There's nothing new there, but it does reiterate that the legislature did like what the Supreme Court did. And so just in general with eminent domain, we almost can't talk about it or mention it without encouraging anyone that is thinking about doing it just to make sure you do it correctly. You know, feel free to call our office with questions. Make sure you get competent assistance in terms of agents you hire and legal counsel, just to make sure that if that is something you're faced with there in your jurisdiction, that you know, you can save yourself a lot of headache in your residents and property owners there in your communities, a lot of headache and hassle as well. So HB 266.
Do you want to comment on your slide?
Well, so Admiral Beverage, there's the Admiral, and that's the Admiral's beverage. So that's the connection there. Thank you. So in terms of HB,
I guess it speaks for itself, right? Sorry, I shouldn't have said it.
That's all right. You're free, as you mentioned before, you are free to interject. You know, anything that will liven this, you know, this discussion of laws and everything up a little bit. So
it's a trap.
It's a trap. Yes. No, we promise no traps here with our presentation today. So, and we do need to credit Brent Bateman, the lead attorney in our office, for this slide. We shamelessly sourced it from him. But there will be, Brent will get his own little moment of fame here later on. So stay tuned and watch what kind of picture Brent gets. So that might hook you, you know, in terms of tuning in for a little while longer. HB 266, limited access highway amendments. So this was an interesting tweak to the law. Previously, if a highway jurisdiction, so whether it was local or state, if that jurisdiction closed down an access point to a property, they simply had to provide reasonable access to that property. Okay, so for example, if on a corner parcel they closed the access down on one street, they could provide access from the other street so long as it was reasonable ingress and egress to that property. This bill changes that a little bit. Now you have to, if you close down access to a property and you don't acquire it or otherwise pay for it or condemn it, you need to make sure that that property maintains reasonable access to that same street. Okay, so that's a subtle change there. If there, so the bottom line is now, in terms of a takeaway, is whenever you're looking to close an access on a property, unless it is basically part of the interstate system or one of a couple of limited access highways that exist in the state of Utah, so basically UDOT would be dealing with that. If you're looking to close an access, you have to make sure that you either pay for it or that you provide reasonable access to that same street. And so that's the bottom line on that one. HB 361. So we did see another billboard bill this session, and it passed. And this one arose out of a case, the Outfront Media case, another Utah Supreme Court case. And this was a situation where, in contrast to the HB 62, this is where the legislature did not like what the Supreme Court said. And so they ended up changing the law with this HB 361. And what happened in the Outfront Media case is a billboard company applied to relocate its billboard in Salt Lake City. And as you know, under certain parameters, if a billboard meets certain parameters under current state law, it can relocate its billboard. And this billboard met those parameters, but Salt Lake said, you know what? And by the way, and this is important, it was not just Salt Lake, it was the mayor's office in Salt Lake. This was not a council decision, but the mayor's office said, you know what, we have a policy in Salt Lake of trying to reduce billboards, and so we're not going to let you. And that triggered a provision in the law that said that they were deemed to require the billboard by eminent domain. And the issue at hand was the billboard owner said, that's great, but since the mayor's office was the one that made this decision and not the council, you did not follow the eminent domain procedures under state law, because under Utah law, it is the city council that needs to approve eminent domain. It's not a mayoral decision. And so the court said, well, for the purposes of acquiring a billboard under this statute, you don't have to follow all of the eminent domain procedures. It's just meaning to say you have to pay them fair market value for it. Well, this bill changes that. It now says if you're going to acquire a billboard, or whether you are deemed to acquire a billboard by eminent domain, you need to follow the eminent domain procedures. In addition, this gives a time frame of 180 days for the jurisdiction to either approve or deny a request for a relocation before it is deemed to have acquired the billboard. And so, takeaway is, if you deal with billboards, keep this in mind, make sure you're clear on it, and know that you'll have to follow the eminent domain procedures set forth in Utah code in order to, acquire that billboard. And so that's HB 361 on billboards. SB 136 is certainly one of the very longest, if not the longest bill of the entire session. Did you read all of it, Jordan?
Of course.
Okay, there are like hundreds and hundreds of pages, right? And so there could be hours set on this bill. It obviously is a major UTA overhaul. This image here represents what some feel happened to UTA, meaning it got smashed. But the bottom line for our purposes is it now allows corridor preservation funds to be used for public transit purposes. Previously, it was for roads, things of that nature, but not public transit. And so this allows now those funds that come and do corridor preservation to be used for public transit purposes. There's all kinds of shakeouts here with this bill that are in the headlines today even again, and so we'll see obviously how that plays out long term. But for our purposes, that's the takeaway that we wanted to make you aware of. And of course, there's also some ability for local jurisdictions in some instances to allow for a tax now for transit purposes as well.
Okay, so moving on to the next kind of general category into land use and development. We have HB 377, land use amendments, and this bill was one that came out of the Land Use Task Force. It was a consensus bill, and like we said previously, it didn't really create any new rules. It just kind of tweaked existing rules, tried to clarify a few things so that as property owners and local governments go to the Land Use Development and Management Act and state law, they can get a better idea of exactly what the rules are without having to turn to interpretive rules in case law and those types of things. One of the first things it did, so we'll kind of go through what those tweaks are and what they potentially mean for local communities. One of the first things it did is it just made a little tweak. Last year's legislation, I think I should have looked before we came, I think it was HB 232 in last year's session. It kind of standardized two terms, a land use decision and a land use regulation. And a land use decision is an administrative decision. For the seasoned planners and planning commissioners, they know that for an administrative decision, you apply one set of rules and you now analyze it a certain way. And for a legislative decision, you have a lot more discretion, right, in the decisions you make and the people you listen to. And so a land use decision is an administrative decision, like a subdivision plat approval or a conditional use permit or a building permit, where a land use regulation is a product of a legislative decision made by a city council or a county commission or county council, considering broad policy decisions, listening to the public and their preferences. And so we're talking about, ordinances, zoning maps, general plans, and those types of things can potentially fall into the category of a land use regulation. What 377 did is it just explicitly stated that, right? So last year, they termed everything that's administrative a land use decision and termed everything that's legislative a land use regulation. In the definition section of HB 377, it makes that explicit, right? That a land use decision is an administrative decision. A land use regulation is the product of a legislative decision. Other tweaks you see include
there's Brent.
There's Brent. We'll talk about him in just a second. Conditional uses, and you're probably wondering, how does this beautiful picture of Brent relate to conditional uses? We'll talk about that in just a second. Cliffhanger. So with conditional uses, again, no new rules were put in place with conditional uses, but there were certain situations, my understanding is, that came up where at the Land Use Task Force, the Property Rights Coalition and the Land Use, the Utah League of Cities and Towns home team, as they call it, the two sides, kind of agreed that, hey, it would be good to put these into state law to kind of clarify some things. One thing they clarified is local ordinances may not contain provisions that conflict with state or federal law. I think property owners have been going around and still seeing the old language that kind of gave the impression that there was a lot of discretion to deny a conditional use. And so they put that provision in there to say that, hey, state law prevails, governs, and local provisions cannot conflict with that. It also clarifies the requirement to reasonably mitigate detrimental effects is not a requirement to eliminate detrimental effects. So as many of you are aware, when you're looking at a conditional use permit application, one of the things you consider is, hey, are there any detrimental effects that this proposed use imposes on neighbors, surrounding uses, the community in general? If you can identify detrimental effects in accordance with the standards that govern conditional uses in your jurisdiction, then you can impose, and what the law says is reasonable conditions to mitigate those detrimental effects. And apparently some communities were interpreting that to mean, hey, we need to find a condition that completely eliminates any possible detrimental effects. And this just clarifies that that's not the case, right? A conditional use does need to be approved as long as you can reasonably mitigate those detrimental effects. That doesn't mean eliminate. Also, conditions imposed must be stated on the record and must be reasonably related to mitigating the proposed uses reasonably anticipated detrimental effects. I think this is related to a Supreme Court, Utah Supreme Court case from this past term, McElhaney versus Moab City. They one of the, among other things related to conditional uses, one of the main points they made is, hey, you need to make your findings on the record, right? So that the property owner, it's explicit to them and they know what the requirements and expectations are. And also if there's any additional review, it's very clear what the rules were and what the findings made were and those types of things. It also states explicitly that a decision on a conditional use permit is an administrative decision, which is related to what we talked about previously. And so to explain the picture, this is a screenshot, an expertly picked screenshot from a video that Brent wrote, directed, and starred in for the land use, or luau, the land use, I'm blanking now.
That's all right, well.
Luau, Land Use Academy of Utah. If you go to luau, luau.utah.gov, then there's some great resources on there. You can see Brent's video explaining conditional use permits. Jim also stars in it.
I have to interject here just briefly. We better speed this up a little bit because I'm watching the time here. But Brent asked me to play the role of an attorney, a land use attorney, in that production. I said, being anxious to do well in my very first starring role, well, smaller starring role, asked Brent, well, how do you want me to, how should I act? Like, what kind of, how should I portray this person? And he said, Jim, I just need someone that's going to be a dry, boring attorney. And then he said, so basically just be yourself. But literally, boom, true quote. True story. Okay, anyway, sorry.
So you can go see Jim in his true form.
True character, there you go. So.
Okay, a few more things that 377 does. It clarifies some things on the vesting rule. And as many of you know, the vesting rule, what we're talking about there, it comes from a 1980 Utah Supreme Court case, Western Land Equities, it's known as, that basically different states, the question is, when someone submits a land use application, what rules apply, and can you change those rules at any point through the approval process? And different states take different positions on where you vest, right? Where you gain a right to be reviewed under a certain set of codes and rules and statutes. Utah's rule is, and this has been subsequently codified in LUDMA, is that at the time that you submit a complete application and pay all application fees, then you are entitled to, as a property owner, entitled to have your application reviewed under the ordinances in existence at that time that you do that. Submit a complete application and pay all fees, right? where some of the questions have arisen recently, apparently, is what rules are we talking about, right? Does that include development standards? Does that include engineering specifications? Some of those questions have bubbled up here and there in different communities. One thing that they did is they clarified and specifically stated that the application is reviewed under applicable, quote, land use regulations, land use decisions, and development standards in effect when the applicant submits a complete application and pays application fees. So that's just a little clarification, a little tweak. Essentially, the rule is, your review, whatever rules apply to the specific contents of the application you've applied for, those are the rules that best, right? And then there are two exceptions, right, to when the vesting rule applies. One being if you formally initiated procedures to amend your ordinance, then when someone comes in and applies during that process, keep in mind that the result of that process is going to be applicable to their application, even though they applied while it was midstream. That's one. The other one is if the government finds approval would jeopardize a compelling countervailing public interest, then you can apply. You can essentially not apply those rules, and you can create new rules to apply. Essentially, is the idea. This clarifies that if you make that finding of a compelling countervailing public interest, you must formally specify it in writing on the record. Again, kind of that theme of providing notice and predictability.
We did have a question on that.
Yeah.
The question was, who determines whether an application is complete? It says the bill didn't specify.
That's a really good question, and in my mind, that's still somewhat of an open question for some. The way I read it, it's complete as to form, right? So they've submitted all the documents that have been asked for in the application. Usually most communities have an application checklist, for instance, right? If they've submitted everything on the checklist. So that doesn't mean that necessarily it complies with all the substantive rules, because often that's kind of worked out as the review process goes along. So the way I read it is that it's complete as to form. In other words, they've submitted all the documents that have been asked for.
Great.
So,
thanks.
Yep. We're running short on time, but improvement completion assurances, some tweaks were made here. I'm trying to think what would be the general takeaway here. Essentially, we'll talk about the primary issue with improvement completion assurance that was kind of clarified here is that last bullet point: the local government may not deny a building permit application if first the developer has posted an improvement completion assurance. And what that is, for those who don't know, is essentially when a developer comes in to, say, subdivide land, he has two options, right? He can either build all the improvements before the subdivision is recorded, which then allows him or her to be able to sell the lots, or while he's constructing the improvements, he can post an improvement completion assurance for the value of the public improvements that need to be installed. And then he can, while moving forward with building the improvements, he can record the subdivision, begin to sell lots, and get a cash flow that way. One question that's come up recently is, okay, in that process, when can he start getting building permits? When does the city have to start issuing building permits? What improvements need to be in place, right? And it says this in certain parts of the code, but it made it more explicit and put it all in one place. It says, as long as the developer has posted an improvement completion assurance and the development meets requirements for issuance of a permit under building and fire codes, then the developer is entitled to receive that permit. Along with that was H. Bill 305 to clarify, okay, what does the fire code say specifically about what type of roads need to be in place for emergency fire access. And the Land Use Task Force did kind of reach some consensus on what that entails and what that means, but there was a bill proposed and passed that makes explicit that temporary roads are sufficient, right? And communities can require compaction tests and make sure that they have a certain level of road base in place so the fire trucks will be able to access construction sites in case of emergency or fire. But at the same time, they don't have to go all the way as far as to put down the final layer of asphalt or concrete or whatever it may be, right? They can, during the construction period of the development, have just a temporary road. The idea being that, you know, when construction vehicles are using it, they don't chew up that brand new road before property owners and homeowners even have a chance to move in. But they can begin to develop and build homes with the idea that once they're done with a few building permits, they could come in and do those permanent roads later, as long, again, as there's an improvement completion assurance in place. I think we can kind of skip over this one a little bit. Essentially, it just makes permanent the 14 and 21-day plan review timelines that were put in place last year. So that's something you're probably already familiar with, that when you're doing plan reviews for building permits, there are certain timelines that apply. That was kind of a pilot program they put in place in the 2017 legislative session. This bill makes that permanent and also clarifies the difference between a plan review and a planning review to prevent any confusion about applicability. These timelines apply to plan reviews, but not the overall entitlement that goes on with a planning review. Small Wireless Facilities Deployment Act, this is one where, you know, the telecommunications industry is basically going through states and trying to get some standardized rules in place to be able to deploy these small cell facilities, which is kind of what they're using for the new 5G technology, LTE technology, as opposed to the big monopoles that are so expertly disguised as pine trees. Now they're going to just basically put them on utility poles and light poles. Keep in mind that Utah, as I understand it, got a pretty good compromise with the industry in that it does allow communities to impose certain non-discriminatory, quote-unquote, health, safety, and welfare regulations, as well as adopt reasonable non-discriminatory design standards for these facilities. There's an annual fee that can be charged for use of the right-of-way, and those amounts are specifically outlined in the state law. And if you have a historic district, you can require certain design or concealment measures on those types of facilities. A few other notable mentions: municipal natural gas facilities were added to the list of public facilities for which communities can collect and expend impact fees. That is specifically for, as I understand it, a municipal natural gas facility provider in the Nephi area, and then it could potentially also apply to Blanding, because I guess they provide their own natural gas facilities. And those communities, well, at least Nephi is growing. They need to be able to find new sources of funding for their facilities, so now they can use impact fees. State regulation of oil and gas, it just basically states that states regulate oil and gas operations. It leaves local governments some authority to regulate incidental surface activity. And then the Utah Inland Port Authority, that's another one that was really heavily covered in the news. For our purposes, an interesting component of it is it gave the Port Authority appeal review of administrative land use decisions made by local governments on land within the Port Authority jurisdiction. An early version of the bill proposed to also give them appeal authority over legislative decisions, which was an interesting proposal. It didn't go through, but it'll be interesting to see going forward as the state identifies what they view as, you know, kind of statewide impact or benefit projects. Will they continue to consider getting involved on a policy-making level in those decisions?
Right. Okay, I'll bring us home here. Just a couple minutes left, and we will wrap this up. So on some general local government types of bills, there's the HB 38 fireworks restrictions. Just be aware that there's now the ability for municipalities to restrict fireworks in certain areas under certain conditions. And then there's also a slightly smaller window for when it's legal to set off fireworks. So if that's something that you think may have applicability to your jurisdiction, take a look at that for some of the details. SB 114, disposal of county property amendments. This is a bill that arose because of a situation out in Tooele County, the Miller Motorsports Park, excuse me. And there's that large piece of property, and the county is looking to dispose of that. And there was some confusion over whether or not they had to go with simply the highest money, the highest cash amount for the property, or whether they could consider things that were not simply that highest cash amount now, but rather the benefit that would bring to the county in the long term. This bill answers that question by saying you can in fact consider long-term benefit if you're a county disposing of a significant parcel. It also clarifies that an average of 2 appraisals will be deemed the fair market value for a significant parcel. So keep in mind this just applies to large significant parcels and in counties. SB 158, municipal business licensing. This is a follow-up, a tweak from the bill last year that said you couldn't charge business licensing fees to home-based businesses that did not have impacts on the surrounding area larger than the residential use alone. This says you can't charge any fee for that. However, it does give a slight exception that if the owner of that business would like a business license that is not required, then you can go ahead and charge, a fee for that license that's not required if they have some other reason for wanting that. SB 167, food truck regulation amendments, also follow up from the bill last year, and this makes some additional restrictions on what local jurisdictions can do to regulate food trucks. It does not take away the ability of zoning to determine where food trucks can operate, but it does provide some restrictions on what kind of fees can be charged, on whether they can be forbidden in zones that already allow restaurants or food services. That can't happen, and some other of those types of regulations here on food trucks. So again, if this is an issue, take a look at that bill for a couple more of the details on that one. Okay, this is it. This is where we wrap it up. So the FEL Bills, a couple here we want to just briefly mention. There's HB 79, the Private Attorney General Doctrine. This is a bill that has been around for a few sessions and expect to come back. And basically what this was trying to do is bring back the Private Attorney General Doctrine, which allows a private citizen who brings a lawsuit and wins to collect attorney's fees against a government if their lawsuit vindicates an important right. And so, again, just be aware that's out there and will likely come back next year. HB 244, local animal control regulation amendments. It seems like every session there's 1 or 2 bills, sometimes more, that are very specific on land use and are trying to address a very specific problem. Well, this is one from this session that would have made it much harder for local jurisdictions to preclude folks from having 1 or more animals on their property. And so, again, be aware that that's out there, and it's something that's going to undoubtedly, a bill of this nature, reoccur next year and in the coming years. HB 267, oil, gas, and mining amendments. So this one would have actually given a few more protections to the surface owners of property when the mineral rights owners came on the surface to extract their minerals from below ground. But again, it did not pass. And SB 183, land use notice amendments. This is a similar bill to that which was run previously. Interestingly, both the prior sponsor as well as this year's sponsor after this year will no longer be in the legislature, so we'll see what future it has. But basically, this would have required local jurisdictions to provide increased notice whenever a proposed land use regulation would, as it said in the bill, have been required higher standards or more stringent requirements than set forth in state code and LUDMA. So that again did not pass. But that's sort of a wrap here on the legislative session. But Jordan, of course, as hopefully everybody knows, there's our contact information. Feel free to call us. We'd be happy to speak with you, answer any other questions. If there's any questions now we can answer, we'd be happy to try to do that. And yeah, we appreciate everybody's time today. So
thanks for tuning in.
Wow, awesome summary here. We do have a couple of questions here that have come in. One I kind of overlooked, and I apologize. I don't know exactly what they were replying to. The question was, has anyone applied for CLE credit for this? And I just wanted to make sure. Oh, that's it. So that's land use. That's probably some.
We have not. Is the short answer.
Yeah, we'll look into that and see the opportunity, see if that's a possibility.
It's a great idea.
It is a great idea.
That is a great idea. All right, I wasn't paying attention exactly what that was. All right, the next one is, what clear and objective standards guide the decision that a home-based business does not create impact more than a SFD?
So my understanding on that is that it was specifically left, I don't know if vague is the right word I want to use, but undefined. The intent being to give the local jurisdictions discretion to decide.
It's not in the bill. The law does not clarify that.
Okay. So, all right.
It's discretion, but don't abuse it.
Yeah.
Okay. Because if this does get abused and legislators get stories about this, then
they'll
define it. And it, probably won't be in a way that it necessarily makes local jurisdictions happy.
Wow. Okay. Great summary. A lot of material. Oh, I had one question. Was there any movement on short-term rentals?
That's a little bit surprising. We probably should have mentioned that at the outset. Given the last legislative session, I think we were all expecting that there would be some sort of possible comeback. But based on the deal that was struck last term, no, there wasn't.
Yeah, we didn't see anything.
No bills, nothing that we saw.
Okay.
That was not a topic of the session. Again, which is surprising given how much there was last session.
Yeah. Awesome. Thank you very much. We appreciate Jim, Jordan, providing this presentation to us today. Once again, you've got their contact information there. We've recorded the session. We'll place it up on the website here, and I think our IT support's a little short today, so it might take a couple of days to get that posted up there. But feel free to go back and review that and share that with others who might benefit from that. And make sure to contact the Ombudsman's office. It's easy. These guys, you notice they're pretty approachable. They're pretty good folks. And if you have a question, give them a call. They don't. They're not going to bite.
No charge. Special price. But one thing we'll say here, Jason, as well, is we'll take a follow-up on that CLE question, and we can let you know, and you can send that out to your members here who may be interested in that answer. So.
Yeah, absolutely. Thank you so much. We'll wrap it with that.
Great. Thanks.
Thanks so much. Everybody go out and have a safe day.